This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're talking about who's on first and in what percentage when there are two insurance companies insuring the same insured's liability to third parties, and how application of diverse other insurance clauses can cause disputes. But at least the two insurers who are involved in this lawsuit protected their insured and then, and only then, litigated their differences. Two insurance companies, Gemini and Zurich, asked the 11th Circuit Court of Appeal to determine what share of a $2 million settlement each was required to pay. The district court entered judgment for Gemini, ordering that Zurich pay $500,000 plus prejudgment interest. Both parties appealed, with Gemini seeking another $500,000 and Zurich challenging the award of prejudgment interest. In Gemini Insurance Company versus Zurich American Insurance Company, the United States Court of Appeal for the 11th Circuit, on October 23, 2024, resolved the dispute over the other insurance clauses. After the death of Josue Vallejo, who was struck by a tractor-trailer operated by an employee of FSR Trucking, 2 of 3 insurers disputed what proportion of the settlement each should pay. Zurich insured FSR through its coverage of commercial for $1 million. Gemini also insured FSR for $3 million. The Vallejo claim settled for $3 million, of which Gemini contributed $2 million. Ryder's Insurance Company, which is not a party to the appeal, contributed the other $1 million. Gemini and Zurich agree that they each owe a share of the $2 million, but dispute how much one must pay. Under Gemini's theory, they each owe $1 million, and under Zurich's theory, they each owe their pro rata share, which is $500,000 for Zurich and $1.5 million for Gemini. The different theories turn on the application of the two policies' other insurance clauses, which generally function to apportion coverage when there is overlapping insurance. Gemini argued that its policy is excess to Zurich's, while Zurich argued that the policies attach at the same level and thus trigger pro rata contribution. Gemini sued Zurich for a declaratory judgment in its favor and an award of $1 million plus interest under claims of contractual subrogation or equitable subrogation contribution. Zurich tendered $500,000 to Gemini to satisfy what it believed was its pro rata share. Gemini, however, continued to litigate for the other $500,000 plus interest on the entire amount. Gemini appealed the district court's ruling in favor of Zurich and sought to obtain the other $500,000. In Florida, where more than one insurer's policy provides coverage for a loss, as the parties agree is the case here, it is appropriate to review the insurance contracts to see if the documents address the ranking or contribution of the insurers. Gemini's other insurance clause provides, quote, "This insurance is excess over and shall not contribute with any of the other insurance, whether primary, excess, contingent, or on any other basis. This condition will not apply to insurance specifically written as excess over the policy," close quote. Zurich's other insurance clause is somewhat different and just slightly different when provides that, quote, "When this coverage form or any other coverage form or policy covers on the same basis, either excess or primary, will pay only our share. Our share is the proportion that the limit of insurance of our coverage form bears to the total of all the coverage forms and policies covering on the same basis. Where two insurance policies contain excess insurance clauses, the clauses are deemed to be mutually repugnant, and both insurers become primary and share the loss on a prorated basis in accordance with their policy limits. Zurich argued, and the district court agreed, that both policies contain excess clauses such as a pro rata contribution results. The 11th Circuit Court of Appeal, however, sided with Gemini, because when two policies contain conflicting other insurance or excess uninsured underinsured motorist clauses, in some an other insurance clause containing the phrase "we will pay the proportion of damages payable as excess" means that the clause was pro rata, even though it also characterized itself as an excess clause. Moreover, the 11th Circuit concluded both policies were primary. The 11th Circuit therefore reversed the district court's resolution of the cross motions for summary judgment with regard to the amount of contribution and remanded the case for entry of judgment in favor of Gemini for the principal amount of $1 million, with the understanding that Zurich had already paid half that sum. Upon entry of the amended final judgment on remand, Gemini will be the prevailing party, and when a verdict liquidates damages on a plaintiff's out-of-pocket pecuniary losses, plaintiff is entitled, as a matter of law, to prejudgment interest at the statutory rate from the date of loss. The 11th Circuit therefore reversed the district court's resolution of the cross motions for summary judgment, remanded for the court to enter judgment in favor of Gemini in the principal amount of $1 million. It also affirmed the award of prejudgment interest on the first $500,000 and directed the court to award Gemini prejudgment interest on the second $500,000 from February 7, 2019 until the date of the amended final judgment. In my opinion, the three insurers of the defendant did the right thing by protecting the insured and then resolving their dispute over the share owed in court. Although insurance companies generally should not sue each other, other insurance clauses invariably raise disputes between insurers and often cause hardship to the insured. In this case, Gemini and the unnamed insurer put up $3 million to settle, and then Gemini and Zurich sued to clarify who owed what to whom. The 11th Circuit found that the district court was wrong because interpreting the competing other insurance clauses should have resulted in a finding that both Gemini and Zurich were primary insurers and each owed $1 million of the settlement, and Zurich owed Gemini $500,000 plus interest. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. If you do, you can subscribe to the blog and receive access to the more than 4,900 blog postings. You can also subscribe to these videos on YouTube and or rumble.com, and if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com. Please tell your friends and colleagues about this blog so they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.